Before we get started, just a great time to go and click that like and subscribe button on this video so you can see when we get new ones coming out. Do it now or the cats will get grumpy. Hello and welcome to Raindrop Works with Heather Van Wild. Today I'm planning on going over a document that I just found out last night was put out by Department of Homeland Security back in April. Discussing the federal response in Portland to how they handled protests regarding Black Lives Matter over the summer, which those who are familiar with our work here know that it was incredibly dangerous and horrific, the likes of which I don't know the last time this town has seen. That being said, there were some things that came out of this document, as well as some very interesting things that I've seen. Time will tell what kind of impact that has going forward for dealing with accountability, but I thought we could go through this document together. It is a little bit long, it's 32 pages, but a lot of it is stuff that can be skimmed over, as it's a lot of, there's a lot of technical jargon and such that it doesn't really apply to most people. But that being said, here we have the report from the Department of Homeland Security's Office of Inspector General, or OIG, stating that DHS had authority to deploy federal law enforcement officers to protect federal buildings in Portland, Oregon, but should ensure better planning and execution in future cross-component activities. When they're talking about cross-component, they're talking about the fact that there was interactions between the Federal Protective Services, Department of Homeland Security, as well as Immigration and Customs Enforcement, which was collectively part of then President Trump's Operation Diligent Valor program, where he took responses to protests for racial equality and amplified the rhetoric due to some non-federally owned statues being taken down by various protesters. So we start off with the cover letter from Joseph Kafari, who is Dr. Joseph Kafari of the Inspector General's office, to the Secretary of Homeland Security, stating that the final report is titled, DHS had authority to deploy federal law enforcement officers to protect federal facilities in Portland, Oregon, but should ensure better planning and execution in future cross-component activities. They've incorporated the formal comments provided by the Secretary's office. The report contains 2 recommendations aimed at improving DHS's preparedness for protecting federal property. Your office concurred with both recommendations. Based on the information you provide in response to the draft report, we consider both recommendations open and resolved. Once your office has fully implemented the recommendations, please submit a formal closeout letter to us within 30 days so we may close the recommendations. The memorandum should be accompanied by evidence of completion of agreed upon corrective actions, and it gives an email address for them to send that information to. Consistent with our responsibility under the Inspector General Act of 1978 as amended, we will provide copies of our report to congressional committees with oversight and appropriation responsibility over the Department of Homeland Security. We will post the final report on our website for public dissemination, including your formal comments as an appendix to the report, which is what we're going over now. This was also sent to the Director of the Federal Protective Service, and some of the things that are found from this are apparently ongoing issues that have not been addressed in previous years. So they start off explaining that they did the inspection because beginning on May 29, 2020, the Federal Protective Service experienced challenges protecting federal property in Portland, Oregon. FPS requested assistance from DHS law enforcement officials. OIG's objective was to assess the authority, preparation, and activities of DHS law enforcement officers deployed to protect federal property. A lot of what happened was protests because they started off focused around the Multnomah County Justice Center, which is right next door to the Hatfield Federal Courthouse. The two properties ended up having a significant amount of overlap when it came to protests. And there was significant vandalism and damage to the federal courthouse property, which was Federal Protective Service's job to protect, and they were having difficulties doing that. At this time they did make 2 recommendations to improve preparedness for protecting federal property, which will be gone over later. To start off with what they found, under 40 U.S.C. United States Code 1315, the Department of Homeland Security had the legal authority to designate and deploy DHS law enforcement officers from U.S. Customs and Border Protection, U.S. Immigration and Customs Enforcement, and United States Secret Service to help Federal Protective Services to protect federal facilities in Portland, Oregon. However, DHS was unprepared to effectively execute cross-component activities to protect federal facilities when component law enforcement officers first deployed on June 4th, 2020. Specifically, not all officers completed required training, had the necessary equipment, and used consistent uniforms, devices, and operational tactics when responding to the events in Portland. Now, it's worth pointing out that component law enforcement officers first deployed on June 4th. It wasn't until almost a month afterwards that protests took on a particular focus with the federal property. So at that time, when things started, it was more of a defensive posture for them. Going to say this occurred because DHS did not have a comprehensive strategy that addressed the potential for limited state and local law enforcement assistance, as well as cross-designation policies, processes, equipment, and training requirements. Without the necessary policies, training, and equipment, DHS will continue to face challenges securing federal facilities during periods of civil disturbance that could result in injury, death, and liability. Additionally, we previously reported concerns regarding DHS's delegation of authority and that the director of FPS did not properly identify DHS employees by name who could exercise authority under 40 U.S.C. 1315b1. DHS response was that they concurred with the recommendations. And we go into, there is a significant table of contents here about the background, the results of the inspection, the recommendations and such, as well as a number of abbreviations that they'll use going forward. So the background, and this is more of the, in the beginning, this is the background to the legal structure of how they're operating in this instance. Pursuant to 40 United States Code 1315, Department of Homeland Security is the primary federal agency responsible for the protection of buildings, grounds, and property owned, occupied, or secured by the federal government. Within DHS, the mission of the Federal Protective Service is to protect federal facilities and their occupants. FPS has broad authorities and jurisdiction to prevent, investigate, mitigate, and defeat threats to facilities and the people who work within or visit these facilities. FPS currently employs over 1,300 law enforcement officers, security specialists, special agents, and mission support staff across more than 9,500 facilities nationwide. When we're talking about federal facilities, in the area where we are talking about, there is the federal courthouse. Across the street, or next door to it, is the Multnomah County Justice Center, which is one of the county jails. On the other side of the Justice Center is another federal building with a park that is on the other side of the street there. So in a 2x3 block area, 3 of the blocks are federal property and 3 are city property. One of the things that was a point of contention was the amount of time that federal officers were spending on city property dispersing protesters. And that is something that is not brought up in this, but it has been discussed in various legal cases that are ongoing right now. Continuing, FPS conducts facility security assessments for assigned facilities across the country. Each FSA, Facility Security Assessment, rates risk to facilities based on factors including mission criticality, symbolism, facility population and size, and threat to tenant agencies. These assessments seek to provide real-time decisional advantages such as warning of potential threats and providing insight into current events, situational awareness, and updates on specific topics. According to Federal Protective Service, it would not be able to accomplish its mission without strong partnerships with other federal, state, and local law enforcement agencies. FPS works with its partners to provide security during critical incidents and demonstrations to protect protesters, the federal employees, and property. FPS establishes memorandums of understanding and memorandums of agreement with state and local law enforcement organizations to coordinate law enforcement activities, including the protection of federal property and persons. The memorandums are mutual agreements between FPS, state, and local jurisdictions that describe law enforcement responsibilities, but are non-binding and do not require state and local law enforcement to assist FPS. Under 40 U.S.C. 1315, the Secretary can designate employees of DHS as officers and agents for duty in connection with the protection of property owned or occupied by the federal government and persons on the property, including duties in areas outside the property to the extent necessary to protect the property and persons on the property. This practice is commonly referred to as cross-designation. In 2005, the United States Attorney General approved the guidelines for the exercise of law enforcement authorities by DHS law enforcement officers and agents under 40 U.S.C. 1315. The guidelines require officers to complete basic law enforcement or criminal investigator training prior to exercising these authorities. Officers must also complete periodic refresher training. And then they reference a document from 2005 about those guidelines. Since 2015, DHS has used its authority 5 times under 40 U.S.C. 1315 to designate component law enforcement personnel to protect federal property and the safety of persons on the property. For example, DHS used the authority to deploy U.S. Customs and Border Protection officers to protect federal property in Baltimore, Maryland during violent civil disturbances. In Portland, Oregon, FPS is responsible for protecting 34 facilities, including the Mark O. Hatfield U.S. Courthouse. According to FPS officials, 7 full-time employees are assigned to the Portland geographic area. Beginning on May 29, 2020, Portland experienced daily protests that were mainly nonviolent. However, there were nightly instances involving civil disturbance, including violent protests, riots, vandalism, destruction, and direct attacks against officers around the federal facilities. The largest protests reported by FPS included 10,000 people near the Hatfield Courthouse and included some individuals throwing bottles and lighting fireworks in the direction of Portland Police Bureau officers. As shown in Figure 1 here, the vandalism and destruction to the Hatfield Courthouse included graffiti and broken windows. To assist FPS in Portland, on June 4th, DHS began deploying officers relying on its authority under 40 U.S.C. 1315. Portland has experienced great disturbance in the past. In June 2018, a U.S. Immigration and Customs Enforcement facility in Portland was closed due to an occupation by protesters who surrounded the facility and prevented government operations and free movement of federal employees. According to an FPS official, the mayor, who is also the police commissioner, directed the Portland Police Bureau not to assist FPS. On June 26, 2020, the President issued Executive Order 13933, titled Protecting American Monuments, Memorials, and Statues and Combating Recent Criminal Violence. The purpose of the executive order was to address, quote, a sustained assault on the life and property of civilians, law enforcement officers, government property, and revered American monuments, end quote. According to the executive order, it continues, the Secretary of Defense, the Attorney General, and the Secretary of Homeland Security shall provide, as appropriate and consistent with applicable law, personnel to assist with the protection of federal monuments, memorials, statues, or property, end quote. On the same day, FPS created the draft operation plan, Operation Diligent Valor, to prevent, protect, respond to, and recover from attacks on federal property in FPS Region 10, which includes Portland. On June 30th, 2020, the Acting Secretary of Homeland Security issued a memorandum creating the Protecting American Communities Task Force Pact to prepare to protect federal facilities and property during the July 4th, 2020 holiday weekend. The acting secretary, which was Chad Wolf at the time, created the pact to assess potential civil unrest and property destruction, and coordinate component law enforcement resources to ensure the protection of people and property at multiple locations across the country. The pact required components to coordinate with DHS Office of Operations Coordination and FPS to complete cross-designation requirements. The Acting Secretary's memorandum assigned OPS as the departmental lead for information sharing, reporting, and cross-coordination responsibilities, and FPS to continue to serve as the departmental lead for protection of federal facilities and property. OPS's mission is to coordinate and integrate operations to support the defendant. OPS's goals include being the primary integrator of operations and decision support to the department and advancing coordination capabilities in support of integrated department operations during both steady state, which is day-to-day operations, and crisis situations. Following the July 4th, 2020 holiday weekend, civil disturbance continued in Portland. FPS officials stated that prior to the civil disturbance in 2020, there was a good working relationship with the Portland Police Bureau. However, on July 22, 2020, Portland City Council voted to cease cooperation between the Portland Police Bureau and federal law enforcement. The Portland City Council viewed federal operations in Portland as an, quote, unprecedented and unconstitutional abuse of power, end quote, by the federal government. According to the Portland City Council resolution, quote, the Portland Police Bureau shall not provide, request, or willingly receive operational support from any agent or employee representing or constituting part of deployment under executive order from the President, be they from Department of Homeland Security, the U.S. Marshal Service, the Federal Protective Service, U.S. Customs and Border Protection, or any other service, end quote. The resolution also stated that, quote, any member of the Portland Police Bureau who provides, requests, or willingly receives operational support from militarized federal forces will be subject to discipline for violating the policies of the elected city council. On July 30th, 2020, Oregon State Police personnel were sent to Portland to assist DHS with protecting federal property. On August 13th, 2020, it was reported that the Oregon State Police withdrew their assistance to DHS in Portland as a result of a lack of prosecutions in the Multnomah County District Attorney's Office. They then fast forward to November in preparation of the election. The National Guard was activated on November 4th, 2020. According to FPS officials, civil disturbances in Portland occurred as recently as February 5th, 2021, when a group of protesters attempted to prevent an FPS contractor from leaving a federal facility and threw projectiles at FPS officers. And they do provide a timeline for the civil disturbance in Portland, which is fairly basic. It starts off May 29th, 2020. Riots began in Portland after the first attack occurred at the Hatfield Courthouse. Also, rioters set fires near the Hatfield Courthouse. June 3rd, 2020, FPS Director seeks first consent of DHS components to cross-designate personnel for assistance. June 4th, the next day, first deployment of DHS personnel to Portland. Fast forward June 26, 2020, the President issued Executive Order 13933, stated Secretary of Homeland Security shall provide as appropriate and consistent with applicable law personnel to assist with the protection of federal monuments, memorials, statues, or property. And this is when Operation Diligent Valor was created. July 22nd was when Portland City Council voted to end Portland Police cooperation. Then they mentioned the National Guard deployment on November 4th, and the civil disturbances continue on February 5th. Between June 4th and August 31st, 2020, 755 DHS officers participated in Operation Diligent Valor at various times. Officers deployed to Portland, including those from Special Response Teams, Special Operations Group, Rapid Protection Forces, and other officers from Federal Protective Services, Customs and Border Patrol, Immigration and Customs Enforcement, and United States Secret Service, as described in Table 1 below. From May 29th through August 31st, DHS officers made 62 arrests, while local police declared 25 riots and made 682 arrests. According to FPS officials, damage to the Hatfield Courthouse caused by civil disturbance was approximately $1.6 million. The estimated cost of Operation Diligent Valor as of August 31st was $12.3 million. So yeah, they spent $12.3 million to mitigate damage that also cost an additional $1.6 million, according to their estimates. They do go on here to further break down, as I said before, the law enforcement. From Federal Protective Services, they had their Rapid Protection Force, which is a team of personnel who are trained and supported to bring enhanced capabilities to situations including terrorist threats, critical incidences, special events, national disasters, and surge operations, comprised of inspectors and special agents. And then the Federal Protection Officers, which are law enforcement officers and trained security experts who provide security assessments, inspections, and oversight for contract guards and respond to crimes in progress, composed of inspectors and special agents. Federal Protective Service had a total of 179 people involved. From CPB, we had the actual Border Patrol provides immediate response capability to emergent and high-risk incidences requiring specialized skills and tactics, which are composed of border agents. And there were 337 of those involved, as well as the Office of Field Operations Special Response Team. They handle interdicting threats, develop and deploy advanced tactics and training, and tests and evaluates new technology and equipment. There were 70 members of that unit. From ICE, we had the Enforcement and Removal Operations Special Response Team, who conducts high-risk enforcement actions and other specialized duties or activities as authorized in furtherance of ICE's immigration enforcement and public safety missions within the scope of ICE authorities, and they are composed of enforcement officers, which we had 85 of them. We had Homeland Security's Investigation Special Response Team, who conducts high-risk enforcement operation and other specialized duties within the scope of its training and capabilities, which was an additional 82 special agents, and then 2 Secret Service agents that were assigned from the Portland resident office. The Secret Service agents, they only conducted limited investigative procedures and did not engage with the public. As we continue, throughout Operation Diligent Valor, the media reported concerns regarding DHS officers in Portland, such as DHS's authority to deploy federal officers to Portland, uniforms, cell phone surveillance, and the use of less lethal devices. Our objective in this report was to assess the authority, preparation, and activities of DHS officers deployed to protect federal property. So that's the background. They basically, they've laid out who was there, from where, and why they were there. And now we're going to go into some of the more nitty-gritty about this. With the results of the inspection, under 40 U.S.C. 1315, DHS had the legal authority to designate and deploy DHS law enforcement officers from Border Patrol, ICE, and Secret Service to help Federal Protective Services to protect federal facilities in Portland, Oregon. However, DHS was unprepared to effectively execute cross-component activities to protect federal facilities when component law enforcement officers first deployed on June 4th. Specifically, not all officers completed required training, had the necessary equipment, and used consistent uniforms, devices, and operational tactics while responding to the events in Portland. This occurred because DHS did not have a comprehensive strategy that addressed the potential for limited state and law enforcement assistance, as well as cross-designation policies, processes, equipment, and training requirements. Without the necessary policies, training, and equipment, DHS will continue to face challenges securing federal facilities during periods of civil disturbance that could result in injury, death, and liability. Essentially, they're trying to say that the reason why they had so much trouble operating was because they didn't expect non-federal law enforcement to pull out and say, no, we're not going to help you do this. And go on. Under 40 U.S.C. 1315, Secretary of Homeland Security has the authority to designate employees of DHS as officers for duty in connection with the protection of federal property in Portland. This authority extends to persons on the property, including duty areas outside the property, to the extent necessary to protect the property and persons on the property. According to 40 U.S.C., designated officers have the authority to enforce federal laws and regulations for the protection of persons and property, carry firearms, make arrests without a warrant for any offense against the United States committed in the presence of the officer or agent, or for any felony cognizable under the laws of the United States if the officer or agent has reasonable grounds to believe that the person to be arrested has committed or is committing a felony, as well as serving warrants and subpoenas issued under the authority of the United States, conduct investigations on and off the property in question of offenses that may have been committed against property owned or occupied by the federal government or persons on the property, and to carry out activities for the promotion of Homeland Security as the Secretary may prescribe. Between June 4th and August 31st, DHS repositioned and deployed 755 officers at various times from Federal Protective Service, Customs and Border Protection, Immigration Customs Enforcement, and Secret Service to assist FPS with protecting the federal facilities in Portland, Oregon. In our review of 63 officer training records, we found officers met basic law enforcement training requirements as outlined in Attorney General guidelines regarding 40 U.S.C. 1315. Although DHS had the authority and met the Attorney General training guidelines, we previously reported and made 2 recommendations regarding the Director of FPS's authority to designate DHS employees under 40 U.S.C. 1315 and proper, by name designation of any DHS employees authorized to exercise authority under 40 U.S.C. 1315 to protect federal property and persons on that property. DHS did not concur with the recommendations. Without properly identifying individuals, DHS saw risks law enforcement officers acting outside the scope of their authority. See Appendix D for previously reported recommendations and status. So it does seem that there was issues that were documented about lack of proper identification, and we'll try to remember to come back to that later when we get to the appendices. They did also mention not all DHS officers were properly and consistently trained. Before they could execute their authority, the Director of FPS required officers to receive a legal briefing on pertinent authorities and jurisdiction, including criminal statutory provisions enforceable on federal property. FPS used a cross-designation roster to identify which officers completed the legal training. We compared their August 7th cross-designation roster of 4,574 trained officers to the 222 officers deployed to Portland as of that date. We determined 36 of the 222 officers did not appear on the cross-designation training roster prior to their deployment to Portland. That's over 10%, almost 15% of the officers that were deployed were improperly trained. And they break down, ironically, both of the Secret Service agents that were deployed did not have the proper training. And I don't know if the fact that they didn't interact with the public may have mitigated that. But between Border Patrol and ICE, it seemed about the same percentage of people were improperly trained for this. And then they go on to point out that deploying officers who are not properly trained increases the risk of officers acting outside of their authority. Officers who used force in Portland without evidence of cross-designation training presented an even greater risk of liability to DHS. In fact, 14 of the 36 officers for whom we found no evidence of cross-designation training used less lethal devices or munitions against a person while deployed in Portland. During our inspection, FPS took steps to improve the training process by issuing officers a memorandum after successful completion of cross-designation training and designating individuals by name. We acknowledge this improvement, but issuing a memorandum after training is completed does not address the lack of a coordination process to ensure only trained individuals are deployed. We also determined that not all officers were properly trained to respond to riots and to conduct crowd control operations. DHS law enforcement operations in Portland were mainly focused on riot and crowd control activities. However, only 7 of 63 officers we reviewed received riot and crowd control training. That's just over 10%. Although this type of training is not required to execute 1315 authority, FPS officials from the Office of Training and Professional Development issued a memorandum stating that, quote, DHS component law enforcement officers cleared for cross-designation can only provide support consistent with their current law enforcement skill sets and equipment. In other words, if you weren't trained for crowd control as part of your normal job, you can't do that here, or you're not supposed to. And for almost 90% of the officers that they checked records on, that's exactly what happened. Additionally, in survey responses and interviews with deployed officers, many identified a need for additional training in these areas. Even the officers knew they didn't have the proper tools when they were sent in. Some officers questioned their involvement in the operation due to a lack of riot and crowd control training. A lack of training in these areas may increase the risk of injuries to officers and the public. In addition to a lack of training, we determined components had inconsistent annual recertification training requirements for less lethal devices. DHS officers are permitted to use less lethal devices to control subjects in the course of their official duties as authorized by law. DHS officers in Portland use less lethal weapons, such as compressed air launchers, 40mm munition launchers, and pepper ball launchers to help control crowds. And they provide pictures of the FN-303 compressed air launcher, their 40mm munitions launcher, and the pepper ball launchers that they use by DHS officers in Portland here. According to the component's use of force policies, officers are required to complete an initial certification for each device issued. All 63 officers we reviewed accomplished the less lethal device training certification. So they were initially trained on how to use their weapons properly. However, annual certification training requirements varied across the components and operational directorates. For example, FPS and CPB policies require annual recertification on specific less lethal devices, such as the FN-303 and pepper ball launching systems, while ICE does not require recertification for devices used by its enforcement and removal operations and Homeland Security Investigation Special Response Team, or SRT. According to officials in ICE's Office of Firearms and Tactical Programs, SRTs achieve proficiency on less lethal devices through training as required by their respective SRT handbooks. For instance, the ICE Enforcement and Removal Operations SRT handbook requires 7 hours of annual training on broad categories of less lethal devices, such as diversionary devices, chemical munitions, and specialty impact munitions. The ICE Homeland Security Investigations SRT handbook requires 8 hours of general training per month. Having a consistent DHS less lethal training policy may ensure a more effective approach in cross-component operations in the future. We previously reported DHS's training inconsistencies for less lethal devices in OIG report. DHS lacks oversight of component use of force. And I did take a look at this document. This was from January 2017. And this was a national issue back then. This wasn't anything directly related to Portland. So again, this was a report that was issued in January 2017. As of January 2021, 4 years later, DHS has yet to address our recommendations to establish a formal entity to oversee component use of force activities, including establishing consistent requirements for less lethal training. They did go on to point out that not all DHS officers had necessary equipment. They did not have the necessary equipment to protect themselves during riots and violent protests in Portland. During the event in Portland, DHS officers were attacked with lasers, fireworks, and Molotov cocktails, and struck by projectiles including frozen liquids, unknown chemicals, feces, and rocks. They then show a picture of green lasers being used on various law enforcement officers. FPS's standardized operational planning process includes a checklist of equipment for critical incidences and special events, such as riot gear, riot baton, crowd control shield, and certain less lethal devices. However, some officers did not have shin guards, face shields, and protective eyewear when responding to the events in Portland. From June 13th through July 30th, DHS officers reported 689 injuries, including eye irritation, blurred vision, and headaches caused by laser attacks, temporary hearing loss and headaches from fireworks and mortars, and wounds from projectiles. And they show a picture of, actually a pretty nice picture of one of the fireworks that had gone off at the courthouse. They state these are sourced from Federal Protective Service. I'm not sure where they would have gotten those from, but other officers said there were not enough less lethal devices and munitions to respond effectively, which those of us who remember the tornadoes of tear gas that were so thick that inmates in the Justice Center jail were having tear gas coming into their cells up on higher levels. It almost asks the question, how much more weaponry did they think they needed? Finally, officers also reported problems with radio communication, such as the inability to communicate with DHS officers from other components. Because of the communications issues in Portland, FPS requested 100 additional radios. Despite identified equipment issues, many DHS officers stated that efforts to protect the facilities were effective. So in other words, their equipment, they had their own frequencies they were using for talking within their own units, but when it was time to work with different units, their equipment wasn't set up for it, and they had to scramble on that. FPS identified similar equipment issues in an after-action report from operations in Portland in 2018. The report found that officers did not have appropriate riot control equipment and experienced interagency communication problems during the operation. Additionally, a senior FPS official noted that since DHS was established, it has not made progress towards improving interoperable communications during emergencies. In November 2012, we issued DHS's oversight of interoperable communications, concluding that DHS did not ensure components had interoperable communication, including the ability to access and communicate over a common channel. Again, these are issues that have been going on for almost 20 years since DHS was first formed. As of November 25th, 2020, 152 days after the operation began, Federal Protective Service has not completed an after-action report for Operation Diligent Valor to identify and address ongoing issues in Portland. And they go on, and this was an issue that has been brought up in various court filings about lack of documentation. Not all DHS officers use consistent uniforms, devices, and tactics in Portland. Officers deployed to protect federal facilities in Portland did not wear consistent uniforms. Officers from FPS, CPB, and ICE all responded to Portland wearing their respective component-issue uniforms. And they give a picture of examples of Border Patrol and Federal Protective Services uniforms. During the operations, both citizens and Congress raised concerns regarding a lack of proper identification on officers' uniforms. Wearing consistent uniforms would provide a unified front, but DHS did not establish a uniform for cross-designation operations. All DHS law enforcement officers' uniforms included police markings, along with patches or badges identifying their component. In our review of DHS photos taken during operations in Portland and through interviews with officers, we found DHS officers complied with component uniform policies and their uniforms were appropriately marked per their respective component policies. The public and Congress also raised concerns about DHS officers' use of camouflage uniforms. For example, Border Patrol and ICE SRT officers initially wore camouflage uniforms similar to the one shown in Figure 6 here. Due to public concerns, some Border Patrol officers transitioned from these uniforms to available alternate ones. One of the big issues that we had was a lack of being able to identify which officer was which. The same kind of issues that we've had with Portland Police Bureau rapid response team officers not having any indication of who they are, leaving us to essentially make wild guesses unless we're able to get good face shots of them. And as we've seen from other reporting, such as in the case of Donovan Labella, when he was shot in the face by a 40mm launcher and suffered severe injuries that almost killed him, he's having trouble in his lawsuit even being able to figure out which department was involved with the attack against him, much less finding out what specific officer was involved. And they move on. In addition, although FPS served as the DHS lead for the protection of federal facilities in Portland, CPB and ICE used a variety of less lethal devices unavailable to Federal Protective Services. For example, ICE and CPB used the 40mm munitions launcher, which FPS does not have. And down below there is a table of what items were available to what units. Also, we found inconsistencies in the components policies describing how to use less lethal weapons. For instance, for the FN-303 compressed air launcher, CPB policy describes how to use the device at different ranges from the target, while Federal Protective Services policy does not include a range. Another example, ICE's use of force policy indicates that the 40mm launcher is deadly force when fired at someone, while the Border Patrol use of policy only directs officers not to target a person's head or neck. In addition to these policy differences, some officers question the tactics used by other components, such as when to engage rioters with force. Without consistent policies and tactics for multi-component operations, DHS risks confusion, limited coordination, and unintended injuries when protecting federal facilities. A few things we can get from that. Using the example of Donovan Labella, we at least know that because he got hit with a 40mm launcher, Federal Protective Services was not involved. We also know that Border Patrol had the full range of less lethal options, while there was a number of them that ICE does not have. And Federal Protective Services, they only have pepper spray, the FN-303s, and pepper ball. They don't have any grenades, any 40mm, none of those. The difference in tactics and when weapon usage is authorized in certain circumstances, that is a huge issue. And those are questions that are brought up anytime these weapons are used. Another thing that I have not seen addressed in this when I did my first read-through was any of our concerns about expired munitions, which we have had significant evidence of, as documented by Dr. Simonis and other researchers that have been out in the field. Moving on, do state that DHS and FPS did not have an established cross-component strategy to ensure effective operations. They were unprepared to execute cross-component activities in Portland, specifically did not have a written plan, policy, or process to ensure a coordinated multi-component response to civil disturbance at federal facilities. Although FPS had an internal operation plan, the department did not have any cross-designation strategies or plans in place to help components properly prepare to execute Code 1315 to protect federal property. Through the PAC, the acting secretary assigned responsibilities for components to coordinate with OPS and FPS, but did not assign a component or office to develop a written strategy. Such a plan, policy, or process would ensure officers were properly and consistently trained prior to being deployed to assist FPS on cross-designation, riot and crowd control, and less lethal device use, have the necessary equipment to respond effectively to riots and violent protests, including protective equipment and interoperable communications, and use consistent uniforms, devices, and tactics. FPS Region 10 drafted an operation plan which included the event description, purpose, and concept of the operation, risk summary, requested personnel, needed supplies and equipment, personnel reporting requirements, and coordination with outside agencies. However, FPS's operation plan only described the type of equipment, tactics, and use of force policies for FPS officers, and did not include a strategy for leading a consistent and united multi-component response. Also, FPS did not create a strategy or contingency plan to address the anticipated threats of civil disturbance to federal properties in Portland and the potential for limited state and local law enforcement support. FPS's December 2018 FSA identified the Hatfield Courthouse as high risk. According to the assessment, civil disturbances will not only continue throughout the current presidential administration, but increase in frequency and impact. Although FPS had agreements with Oregon State Police and Multnomah County Sheriff's Office, the agreements are non-binding and do not require state and local law enforcement to assist FPS. FPS did not have an agreement in place with the Portland Police Bureau, the primary police department with jurisdiction around the courthouse. According to FPS, it relies on state and local law enforcement to support the protection of federal property. However, it did not use its FSA and the potential for limited state and local law enforcement support to develop a contingency plan for protection of federal facilities. Contingency plans could help FPS better plan for protection of persons and property in high-risk locations and inform department strategies for multi-component operations, assisting FPS with its protective service mission. Essentially, going forward, they are probably going to start creating all of these plans with the expectation, both here and in other parts of the country, that they may not have the support of local law enforcement when it comes to protecting federal property. And they say, without the necessary policies, processes, training, and equipment, DHS will continue to face challenges securing federal facilities, particularly high-risk facilities during periods of civil disturbance. Further, limited planning and preparedness could result in injury, death, and risk of liability. So the first recommendation was they recommend the Secretary, in coordination with DHS components and FPS, establish and implement a plan, policy, and process to improve preparedness for multi-component response to further instances of civil disturbance at federal buildings, including a process for designating component personnel and verification of required legal training completion, equipment and training needs and requirements, and consistent tactics and operational policies. Their second recommendation was for the Director of the Federal Protective Service to establish contingency plans, including necessary equipment for responding to civil disturbances at high-risk federal facilities based on federal security assessments, non-binding agreements with state and local law enforcement, and expected level of support. DHS did concur with both recommendations. They also received technical comments on the draft and made revisions as appropriate. They consider both recommendations open and resolved. And a summary of management responses are as follows. The first recommendation, which was unifying the planning and coordination before this happens, is that FPS will develop governance documents and processes for a comprehensive, cohesive, and transparent approach to civil disturbances at federal facilities. These efforts will include finalizing a policy document for designating DHS component personnel under 40 U.S.C. 1315 and verification of required legal training completion, completing a public order policing directive reflecting multi-component support, additional training, procurement of equipment, and sharing this policy document with other DHS operational components. The estimated completion date was June 30th of 2022, so they're anticipating within the next year that'll be addressed. The Office of Inspector General's announcement of their response. They are responsive to the recommendation. They consider this recommendation open and resolved until DHS develops and implements the government's documents and processes for a comprehensive, cohesive, and transparent approach to civil disturbances at federal recommendations. Going on to the second recommendation, Federal Protective Service concurred for the recommendation to prepare contingency plans. They will establish contingency plan for responding to civil disturbances at high-risk facilities, and they estimate a completion date on that by the end of March of 2022. Again, the OIG office states that the actions are responsive to the recommendation, and they consider it open and resolved until FPS establishes a contingency plan for responding to civil disturbances at high-risk federal facilities. They then go on to Appendix A is the objective, scope, and methodology, which basically goes into how they gathered the information they used to reach their decisions. They said that they reviewed relevant authorities and applicable policies, interviewed officials from FPS headquarters, from Region 10, the DHS Office of Operations Coordination, Border Patrol Office of Field Operations, CPB Border Patrol, Air and Marine Operations, ICE Homeland Security Investigations, and ICE Enforcement and Removal Operations. They interviewed 19 officers deployed to Portland, administered a survey of 354 officers deployed to Portland, and received 35 responses. So they sent out a survey to a significant portion of the officers deployed, only got 10 of them back. Based on the limited number of survey responses, we used the information gathered only to supplement and corroborate other inspection procedures. We also interviewed officials from the Marshal Service stationed at the Hatfield Courthouse in Portland, Oregon, and additionally revisited the Federal Protective Services training facility in Alexandria, Virginia. They reviewed tactics, photos, limited selection of injury, intelligence, and use of force reports applicable to operations in Portland. Also reviewed DHS coordination and memorandums of understanding and agreements associated with protection of federal property. The special agents deployed from Secret Service conducted limited investigations and did not engage with the public. Therefore, they did not include them in review of uniform policies and injury reports. They did confirm they reviewed a limited selection of training records for officers deployed. They, ensuring that the computer information was accurate, they also checked through, make sure that the computer systems were accurate, as well as verifying the records through other means. And finally, during our review, we enlisted information from the components regarding their use of cell phone surveillance equipment in Portland. The components reported that no equipment was deployed to obtain cell phone information or locations during operations in Portland. According to ICE officials, the cell phone information obtained during the operation was done through applicable consent procedures or the search warrant process. One of the things that was brought up as a concern was theories of stingrays and other such surveillance devices being used to try to mass document who protesters were, where they were from, which was raising constitutional questions. And this is saying that any information that they did get was done through judge-authorized search warrants or consent was given. Then we go on, and there is, in Appendix B, there is the letter from DHS with the comments about the draft report that was sent, where they do say the circumstances in Portland, Oregon were particularly challenging because of the level of violence directed against law enforcement officers and facilities, the persistence of that violence over time, and the extent to which law enforcement was prohibited by their political leadership from cooperating with federal counterparts. For example, during the deployment of Portland, Oregon between June 26th and September 30th, FPS personnel reported 205 injuries, such as to the ankle, back, eye, foot, hand, groin, knee, and shoulder, as well as contact with chemicals and objects. Furthermore, DHS and other law enforcement officers were attacked with Molotov cocktails and other incendiaries. And they're stating that this information was sourced from situational reports and from the Department of Labor's Employee Compensation Operations and Management portal. So basically looking at almost like workman's comp claims. They say that wrist rockets and chemicals were also used. Multiple arrestees also possessed more frequently seen weapons, including knives, machetes, and pipe bombs. Protester tactics, techniques, and procedures infrequently seen by law enforcement officers were also often introduced in Portland. For example, the report noted that officers were attacked with lasers, commercial-grade fireworks, frozen liquids, and other projectiles. Regardless, the department responded quickly to these new threats, for example, by assessing available off-the-shelf laser protective eyewear and quickly procuring it for deployed personnel. DHS components have also since continued research to identify better personal protective equipment, and FPS initiated delivery of laser protective gas mask inserts to provide eye protection when officers are wearing their masks without compromising respiratory protection. So in other words, in the future, you expect to start seeing at least the federal officers having better protection against the use of laser pointers. Another example of novel tactics was the use of unmanned aircraft systems that repeatedly threatened public safety due to unsafe flight operations and which conducted illegal intelligence, surveillance, and reconnaissance activities. It appears they're saying that there were use of drones by people in the crowd, and that's something I haven't heard about, so I don't have any more details about that. The department carried out successful counter-UAS operations that responded effectively to this emerging threat. Over the course of one 120-day period, there were 1,784 UAS flights in violation of the FAA's temporary flight restrictions, which there was for a significant period of time. Most of the downtown area was a no-fly zone when it comes to drones. They say there were 5 custodial arrests for violation of Title 49 USC 46307, violation of national defense airspace. They said they are committed to improving its public order policing capability. They conducted a summit from January 13th through 14th of 2021, attended by a wide range of federal, state, local, international, and academic partners, assessing the state of the art and identify opportunities for enhancing effectiveness. They are now developing a doctrine specific to FPS public order policing, which will drive policy training and equipment selection for FPS, and will be shared with other operational components for situational awareness. So there's a lot more information there about what the Federal Protective Service is planning to do going forward. And then the second half of this letter is going over what was talked about before. It's their response to the recommendations. We do also have here Appendix C is photos and descriptions of the various less lethal devices and what units were deploying them, which is more of just reference at this point. Okay, now there is an Appendix D. These are previously reported recommendations and status for management alert, referencing recommendations made back in November of 2020, where they recommended the Acting Secretary of Homeland Security ensure the Undersecretary for Management, the Director of the FPS, and anyone else seeking to designate DHS employees have received proper delegated authority to do so. DHS did not concur with the recommendation. DHS states that it has consistently maintained its legal position in relative legal proceedings, that Mr. Mikulinin validly served as acting secretary. Until a federal court definitively determines that question, it is premature to take additional steps to ensure the FPS director has designation authority under 40 USC 1315. I believe what this is coming down to is the essentially the Cuccinelli effect, where at the time President Trump, instead of running his picks for leading different agencies through the Senate like he was supposed to, he appointed acting people and then never sent them for confirmation through the Senate. According to the way the law is set up, he's only supposed to be able to do that for a certain amount of time. And at the time, Mr. Cuccinelli ended up going past the amount of time. He got pulled out, and Chad Wolf came in as a new acting secretary. But again, this was somebody who did not go through the proper confirmation process with the U.S. Senate. Federal courts have come down and said that certain actions that Cuccinelli took after that timeline ran out were considered unconstitutional because he was not confirmed to the position. And using that as a guide, there is a decent chance that we were looking at Chad Wolf also being in that situation of not being able to exercise these duties because he was time barred, which brings into questions about the constitutionality of the entire Diligent Valor operation. And this is why they're saying that since the federal court hasn't definitively answered the question, they weren't going forward on this. On February 4th, 2021, DHS provided an updated response to the recommendation. They continued to assert that former Acting Secretary McAleenan was validly serving when he delegated the authority to designate DHS employees to the Undersecretary for Management. Although the department's position as the authority was properly delegated, out of an abundance of caution, the FPS Office of the Director, in coordination with DHS Office of General Counsel, will review whether any additional steps to include ratification of the delegation should be taken to ensure the FPS Director has the authority to designate DHS officers under USC 1315b1. DHS estimates these actions will be completed by May 31st, which was a month and a half ago. The second recommendation was to the Director of Federal Protective Service, or the designee, exercising properly delegated authority to designate by name any DHS employees authorized to exercise authority under that statute. Again, DHS did not concur with the recommendations. Their reasoning was to say that FPS had properly designated officers already, which made the recommendation unnecessary. DHS suggested that OIG improperly construed the laws requiring by-name designation of officers and did not acknowledge that FPS maintains a list of employees who completed the cross-designation process. On February 4th, DHS provided an updated response to the recommendation. They continued to disagree. However, the FPS Director instructed FPS to leverage its technology to modify the online 1315 legal training to automatically generate individual officer designation letters signed by the FPS Director upon the officer's certified completion of training. According to DHS, this results in an immediate individual by-name letter to each designated employee upon the completion of training. And this process was implemented on October 1st. So at this point, although DHS and OIG have not agreed on the reported findings or recommendations, DHS's planned corrective actions are responsive to the intent of the recommendations. We informed DHS on February 19th these recommendations will remain open until DHS provides support that the Undersecretary for Management, the Director of the Federal Protective Service, and anyone else seeking to designate employees has received proper delegated authority to do so. Then Appendix E is just a list of the different government agencies that were sent out. This also includes the Congressional Oversight and Appropriations Committee. And then that brings us to the end of it. Now, there are a few things that I've seen that, to me, seem to be less well fleshed out. Again, there was no mention of anything about expired munitions, which we have seen ample evidence that munitions that were being used on nights when it was only responses from federal officers were years expired based on the shelf life, which the way the chemical munitions breaks down, it can actually make them even more dangerous than the significant danger that they were already brought with. We still don't seem to have anything that will help to identify individual officers when there are cases where they act outside the scope of their duties, such as the potential incidences around Donovan Labella being shot in the face with what would have generally been considered lethal force. 40mm canisters are large, fairly high velocity projectiles, and it hit them right in the middle of the face. So those are things that definitely want to continue watching, but a lot of those things will end up being addressed through federal court systems with various lawsuits that are in the planning stages and are already ongoing. So those will be watched by myself and various other groups.